Good afternoon, everyone. A very warm welcome to all the participants joining today. We'll start the session without further delays. We're truly honored to have you with us for this highly anticipated webinar. Today's session promises to be insightful, engaging, and highly relevant for all professionals, students, and corporates alike. Before we begin, a few quick housekeeping announcements. Please ensure your microphones are on mute during the session. You may drop any questions in the chat box and we'll take them up during the question and answer sessions towards the end. A feedback session also will be shared with all the attendees, and the certificate shall be issued based on the responses from the feedback. So stay with us till the end. Now, without further ado, it's my pleasure to introduce you to the speaker of the day. Our speaker today is a well-known in the corporate and academic world. C.S. Mithun B. Shenoy, who hails from Kerala, the goat's own country. C.S. Mithun is a fellow member of the Institute of Company Secretaries of India, ICSI, a postgraduate in commerce, and also has completed an intermediate stage of the ICMAI, the Institute of Cost Accountants of India. Currently, he serves as the Deputy General Manager, the Secretarial Department at Manappuram Finance Limited, brings with him over 14 years of rich professional experience in the corporate compliance, a legal frameworks, and the governance structure. He has served as the company secretary and the compliance officer of reputed listed companies, including Kitex Garments Limited and group entities. His earlier associations include STEL Holdings Limited, Harrison's Malayalam Limited, and the Federal Bank, showcasing his versatility across different industry verticals. Beyond his corporate roles, C.S. Mithun is a passionate academician and speaker. He has been a visiting faculty for ICSI Kochi chapter and others since 2014 and has recently joined the ICMAI Cochin chapter as faculty for corporate laws and security laws. He has delivered numerous lectures at the universities and institutions across CUSAT and other several prominent colleges across Kerala. He also has served on the interview board of the government companies for recruiting professionals and a currently governing body member of Wizard Group of Institute. C.S. Mithun is also a regular contributor to the ICSI Chartered Secretary magazine, where he has included thought-provoking articles on corporate and legal topics which are widely appreciated. In fact, he has been a Best Article Award for his contribution. He runs his own blog, MIBS Learning Center, where he consistently publishes articles and research-based content on contemporary corporate topics. During his chairmanship, under his visionary leadership, the chapter has also won the National Chapter Award for the very first time and the Best Chapter in Golden Grade category, presented by Sri Jagdeep Dhankar, Honorable Vice President of India at the National Convention in Varanasi in the year 2023. So, what are we here to explore today? We are going to look at something quite transformative in India's capital markets, the Social Stock Exchange, or the SSE. Introduced under SEBI's regulatory framework, the SSE is a dedicated platform that allows non-profit organization and the social enterprises to raise funds from the public. It is a significant step for social impact investing the ESG frameworks, and the sustainable finance in India. But for legal professionals, CS aspirants, policy advisors, and law students, this opens up a whole new world of relevance and opportunity. In this session, Mithun sir will walk us through the legal compliance structure of the social stock exchange, SEBI's listing norms for the non-profit organizations and the social enterprises, the role of legal professionals and the advisors in this space, and most importantly, career avenues in the world of social capital markets. So without further delays, let's get started. I now invite C.S. Mithun Shenoy to take over and guide us through this exciting new frontier where law, finance, and social impact converge. Over to you, sir.
Thank you, Akshata. Is it audible?
Yes, sir. Yes.
So special thanks to Akshata for connecting me to this program. It was informed to me that beneficiaries to this program would be legal students, legal graduates, and other profession from different verticals. So I have structured this session in such a way that it is a capacity building program. But I just want to tell you one or two things. Is one, after this session, you should go through certain SEBI regulation. I'll tell you which old regulation you have to refer. That you have to refer periodically. Second thing is circulars, which SEBI used to publish maybe on a monthly basis or periodically. That too also have to be referred. So you have to keep on updating on this topic, otherwise you will be updated. So enjoy learning and love learning. So with this, let us start today's topic. Let me exhibit my PPT here. Can you see my PPT?
Yes, sir.
Yes, sir.
Is it functioning? You can see my other slides also.
Yeah. No issue, sir. It is
Oh, okay. So let us move on to today's topic, that is India's social stock exchange and opportunities for legal professionals. So I have divided this topic into four sub-themes, that is rationale behind social stock exchange, concept of social stock exchange vis-a-vis social enterprises, legal and regulatory framework governing social enterprises, opportunities for budding legal professions. So I will connect SEBI regulation and some provisions under Companies Act 2013. So I'll take maximum of 1 hour, 10 minutes to complete this session. That will be followed by question and answer, maybe for 5 to 10 minutes. Okay, shall we start?
Yes, sir.
Yes. Okay. So moving on to first something, that is rationale behind introducing social stock exchange in India. In India, social enterprises plays important role in social development. So social enterprises means there are NGOs, voluntary organization who plays key role in social activities in our society. But what we felt is that they lack social fund for investing in social activities. So there are various sources for which they can raise fund. They are new channel as well as old channel. New channel include corporate social responsibility, impact investing fund, socially responsible investing. So let us go through each topic. Corporate social responsibility. You will be well known with this topic, and this topic is introduced for the first time in the history of Companies Act, and uh, the corporates are using resources of society, and nothing is given back to the society. So for the first time in the history of Companies Act, corporate social responsibility is introduced under Companies Act 2013 under section 135. So 135, you have to read along with a rule which is called the Companies CSR Policy Rule 2014. What provision says is that eligible companies have to spend minimum of 2% of 3 years average net profit for social activities. So who is eligible company? Eligible company means it is a company with turnover of more than 10,000 crores, net worth of more than 500 crores, and net profit of more than 5 crores in immediately preceding financial year. So these companies have to constitute a separate committee which is called a CSR committee. This committee will look after certain terms of reference, like one, they will constitute CSR policy, which contains which all activities in which social fund will be invested. Second thing is annual action plan for CSR activities for a financial year. And third thing is periodical review of CSR activity. And fourth is annual report on CSR activity will be submitted to the board for deliberation and approval. So this is the terms of reference of CSR committee. So social activity is prescribed under Schedule 7 of Companies Act 2013. Schedule 7 says about certain activities where this eligible company have to spend their fund, which includes eradication of hunger and poverty, malnutrition, education, healthcare, then women empowerment, like that. So these are the CSR activity in which eligible companies has to spend their fund. So that's all about CSR. Next topic is impact investing. Impact investing is another name of CSR, which states that if enterprises investing in social activity, its impact should be measurable in terms of social and environmental measures. I'll tell you one example. See, in a school, a session has been conducted last year on robotics and AI. And what impact study will do is that, see, after 6 months or 1 year down the line, the social auditor will go to school and ask students what are the things which were discussed in that that seminar relating to that robotic and AI this thing. So if students can answer to that question, then very well we can say that this activity has impacted particular session of people. So that is impact investing, this thing. Third concept is social responsible investing. It is the other name of CSR. So these are the new channels through which fund will be raised for social activities. There are traditional methods like philanthropy, government agencies, etc. They used to collect the fund and do the charitable activities. So these are the sources from which social fund will be collected. Okay, so I said that there are lack of fund which social enterprises are facing. So the solution to that will be social stock exchange. The social stock exchange is nothing but it is a platform where the entrepreneurs and donors will come and each other and raise the fund for social development. So as the name suggests, social stock exchange will be, this fund will be utilized only for social activities and no return and a principal amount will be given to the investor. That means at the end of the tenure of a particular instrument, that instrument we will discuss. At the end of particular instrument, investor will not get any return or principal amount. So this is the rationale behind introducing social stock exchange. Move on to concept social stock exchange vis-a-vis social enterprise. As I said, social stock exchange means it is a electronic fund raising platform that allows alternative fund for raising structure to the social enterprise. Here there are three topics which we need to be discussed in detail. One is social enterprise. Second thing is instrument which is used for raising fund, and social activities. So we will discuss in detail these three topics. First topic would be social enterprise. Social enterprise means enterprises who is involving in social activity, which includes enterprises with the profit motive. Okay, so social enterprises consisting of two types. One is non-profit organization and two for-profit organization. Both these organizations' objective would be social intent and social impact. So we discussed that under Companies Act, there is a schedule which is called Schedule 7, which says about social objective like eradicating hunger, poverty, malnutrition, promoting health care, supporting education. So these are the social objective. So social enterprises should invest this fund in social activities. So these are the social stock exchange which is functioning all over the world. As on date, there are around 10 social stock exchange which is functioning in various countries. And initial social stock exchange was introduced in Brazil in the year 2003. And in most of the social stock exchange, non-profit organization are allowed to raise the capital. But only one stock exchange, that is in UK, allows a for-profit company to raise the fund for social activities. Next topic is, why do we require social stock exchange? Main reason why the social stock exchange was introduced, because in the year in the financial year 2019-20, Finance Minister at Center Nirmala Sitharaman had introduced a concept which is called a social stock exchange, mainly to mitigate the fund due to this COVID-19 pandemic. We all know that we had affected COVID-19 pandemic, and various voluntary organizations were functioning to rebuild the livelihood of the society. So for that, we require fund. So central government had introduced this concept in the year 2020. This is the one of the main reason why social stock exchange was introduced in India. Second reason is visibility. Like other stock exchange, like a main board stock exchange, MSME exchange, institutional trading platform exchange. Likewise, this exchange also gives visibility. Visibility in the sense, once this instrument, there is an instrument which is called a zero coupon, zero principal instrument. That instrument can be listed in the stock exchange. So this will allow these enterprises to give visibility and as well as goodwill. So visibility will be increased. That is the second reason. Third reason is access to the capital. Actually, we had seen various IPO which were released last 2 weeks, right? That is HDB Financial Service, then Wellrise Industries, etc. They raised fund from the social market. So mainly they come to the stock exchange to raise the capital. Likewise, social enterprises can raise capital from social stock exchange. Fourth reason, impact measurement and reporting. See, social enterprises raises capital mainly for spending for social activities, right? So this activity must be measured and that should be reported to the stock exchange. So impact measurement and reporting will happen once it is listed in the social stock exchange. Fifth reason, bridge the funding gap for social enterprises. Social enterprises are coming to the exchanges mainly to raise the capital, right? So this act as a bridge finance for social enterprises to spend towards social activities. Second last point is helps to create social investment ecosystem for entrepreneurs and investors. See, ecosystem means it is a platform where enterprises and donors are coming together for making a discussion and for making investment. So social investment ecosystem will happen through social stock exchange. And last reason is diverse funding instruments. So with introduction of social stock exchange, we got a separate instrument which is called zero coupon, zero principal instrument. We will discuss this topic in detail in coming slide, but I'll tell you what this zero coupon, zero principal instrument means. This instrument is a debt instrument, as the name tells that no coupon, no principal instrument. No coupon means you won't get any interest. No principal means you won't get any money which is invested in the social enterprise. It is just like donation which you are giving for the charitable purpose. This is what a zero coupon, zero principal instrument means. So we have completed 2 topics. Any doubt? Any doubt? Request audience to keep your voice muted. Okay, so we have completed 2 sub themes, that is rationale behind introducing social stock exchange and the concept social stock exchange. And we are moving on to one of our major topic, which is called legal and regulatory framework governing social stock exchange. We have 2 major SEBI regulation, that is SEBI ICDR regulation and SEBI LODR regulation. SEBI ICDR regulation tells about if a company is going for IPO, FPO, or if listed company goes for rights issue, bonus issue, likewise, that company has to comply with this regulation. So a new chapter is introduced in this regulation, that is chapter 10A, which comprises of regulation 292A to 292B. So this regulation tells about provision relating to social stock exchange. Okay, and second major regulation is SEBI LODR regulation. LODR regulation is listing obligation disclosure requirement regulation 2015. Listing regulation is mainly the applicable is nothing but once we raise capital from primary market, that instrument will be listed in the secondary market, that is stock exchange. Once that instrument is listed in the stock exchange, we need to comply with a regulation, that SEBI regulation. Its name is SEBI LODR regulation. So SEBI LODR regulation were amended to introduce chapter 9A, consisting of regulations 91A to 91F. So it tells about a reporting requirement which needs to be complied with by social enterprises. And there are other regulation also. This regulation were amended because of amendment in ICDR regulation, that is SEBI Alternative Investment Fund Regulation 2012. So in this regulation, which tells about social impact fund. So anybody who want to invest in social impact fund, that entity has to comply with SEBI Alternative Investment Fund Regulation 2012. And we have a separate SEBI circular, that is SEBI circular on framework on social stock exchange, dated September 19, 2022. So this circular has to be read along with SEBI ICDR regulation to get clear meaning what the provision says about. So let us move on to first SEBI regulation, that is SEBI Issuer Capital and Disclosure Requirement Regulation 2018. So whenever we whenever we go through a SEBI regulation, first thing you should keep in your mind is you have to read applicability, then you have to read the definition. So first move would be we must go through various definition under this chapter, that is chapter 10A. So first definition is draft fundraising document. Draft fundraising document is an offer document which is issued by NPO, non-profit organization, as a part of public issue of a zero coupon, zero principal bond. So whenever a entity is raising capital by issue of instrument, that entity has to give a offer document to the investor. That offer document is called a draft offer document. Why it is called a draft? Because this document has to be submitted before social stock exchange for their comments. Once social stock exchange gives the comments, that has to be incorporated in this document. Once we incorporate this comment, that document will become final fundraising document. So draft fundraising document together with final fundraising document are called fundraising document under ICDR regulation. Okay, so We are moving on to second topic, for profit social enterprise. In the name itself, it says for profit social enterprises. That is, company or body corporate which is functioning mainly for the purpose of profit, and they are involving in social activity. Company or body corporate mainly functioning for the profit, and they are involving in social activities. But this for profit social enterprises does not include section 8 company. So this is what FPSC means in short. Third definition is not-for-profit organization. Not-for-profit organization is a social enterprise which includes charitable trust under Indian Trust Act, state charitable trust, charitable society, section 8 company, and any other entity specified by board. Board means SEBI. So these are the social enterprises which is coming under NPO. So these NPOs can issue that is a zero coupon, zero principal bond to the investor for raising the capital. Next topic is social impact assessor. My dear advocates, legal students, so this is our scope for scope under social stock exchange. See, we can act as social impact assessor. Earlier, its name was social auditor. Now they changed their name to social impact assessor. Who is social impact assessor? Three conditions we have to keep in your mind. To become social impact assessor, individual, that is, we have to register with self-regulatory organization. So what is self-regulatory organization? Self-regulatory organization means there are certain organization which is regulating social impact assessor. Like we have a Institute of Chartered Accountants of India, self-regulatory organization, Institute of Company Secretaries of India, self-regulatory organization, Institute of Cost and Management Account of India as a self-regulatory organization. So likewise, we have to get registered under self-regulatory organization. That is the first condition. Second condition is we have to pass a certificate course conducted by NISM. NISM means it is a academy introduced by SEBI, National Institute of Securities Management. So there is a certificate program conducted by NISM that we have to qualify. That is the second thing. Third thing is that we have to hold valid certificate. Valid certificate means that NISM certificate should be valid. Why is it prominently mentioned here is that NISM certificate will be valid maybe for 1 year, 2 year, 5 year. So once it is lapsed or once this validity loses, you have to again write the exam and you have to get the certificate. So that certificate is a valid certificate. So to become social impact assessor, 3 things has to be kept in your mind. One is you have to register yourself with self-regulatory organization. You have to pass the examination conducted by NISM, and you have to hold valid certificate issued by NISM. That is social impact assessor. Next topic is social impact assessment firm. Social impact assessment firm is firm which is employing social impact assessor and has track record of 3 years for conducting social impact assessment. So social impact assessment firm is, it is a entity, it is a firm which is employing social impact assessor and has track record of 3 years of conducting social impact assessment. So how can we track that 3 years? It is we can present our financials, we can present our activities which is involved in social impact assessment. So in that way, we can show that we have track record of 3 years in social impact assessment. Next topic is social enterprises. As I told you, social enterprises includes 2 organizations. One is not-for-profit organization and for-profit organization. This both organization has to meet eligibility criteria prescribed under this chapter. This chapter means 10A of ICDR regulation. That we will discuss later. Next topic is social stock exchange. We have already discussed social stock exchange means it is a segment under stock exchange which is having nationwide trading terminal which allows social enterprises to raise the fund. Yes. So we have done away with definitions. Next, we are moving on to applicability. So whenever we are reviewing any SEBI regulation, first and foremost thing you have to keep in your mind is you have to check the applicability. So what is the applicability? Whether we are whether we need to comply with ICDR regulation. So answer to this will be applicability. You have to check applicability. So there are three instances wherein social enterprises need to comply under ICDR regulation. One is NPO seeking only registration from social stock exchange. There can be instance that non-profit organization want only registration from social stock exchange. They don't want to raise fund from such exchanges. So that is the first instances where NPO has to comply with ICDR regulation. Second instance of applicability will be NPO seeking itself to be registered and intending to raise the fund. Suppose if social enterprises, that is NPO, is going to get the registration and they are intending to raise the fund, then that case also they have to comply with ICDR regulation. And third instance would be for-profit organization seeking to be identified as social enterprises. See, here for-profit organization means it is a company or body corporate which is already listed or unlisted under SEBI regulation. So that is the reason why here it is mentioned that registration is not mandatory for for-profit organization. Instead, they have to identify itself as a social enterprise. That means they have to satisfy eligibility criteria. So these are the three instances which entity has to comply with ICDR regulation. You can see a pictorial representation from where you will get an idea about how this is functioning. As I said, social enterprises consisting of a non-profit organization and for-profit organization. Non-profit organization, NPO is required to mandatorily register itself with a social stock exchange. There is no relaxation for that. It is mandatory for NPO to get registration from social stock exchange. And second thing is that fundraising and listing. See, fundraising and listing is optional for NPO. If they want to raise fund from social stock exchange, they can do so. If they are not interested, they need not raise the fund and they need not comply with reporting requirement. And NPO can raise fund by issue of certain instruments. These instruments includes zero coupon, zero principal bond. As I said earlier, zero coupon, zero principal bond is nothing but it is a debt instrument with no coupon. No coupon means you won't get any interest or return. Zero principal. Zero principal means whatever you are invested, you won't get that fund. It is just like a donation which you are giving for charitable purpose. That is called zero coupon, zero principal bond. Second instrument is schemes issued by mutual fund. A fund can be raised through schemes issued by mutual fund. And third one is development impact fund. Development impact bond. This is a new instrument which is introduced in a latest stage. I mean, maybe in last 1 year. So development impact fund is nothing but it is a bond which is issued to the investor, and investment will come only after that particular social activity. You got my point, no? Development impact fund means It is a bond issued by enterprises, but that fund will be collected only after social activities. So this fund will come only after social activity, and they will assess the impactment. That is, whether it is impacted in the society, that donor will check, that is investor will check. So this is the speciality of a development impact fund. So development impact fund, in nutshell, it means fund will come only after conducting social activity. It will come only after completing particular social activity. So these are the instruments through which fund can be raised by NPO. So NPO, their registration is mandatory, but this listing and this thing is optional for them. Fundraising is optional for them. So second, social enterprises, for-profit enterprises. For-profit enterprises. So for-profit organization, registration is not mandatory. Registration is not mandatory, but they list their security in the main board of stock exchange, like equity shares listed in main board, MSME board, institutional trading platform, likewise. So listing is mandatory, but no registration is required for profit organization. So they can issue equity shares, issuance of debt instruments, etc. So we have discussed what is social stock exchange, which all instrument used for raising capital, and what are social activities. So next we will discuss who all are eligible investors. So who all are eligible investors? I will tell you in detail these three concepts, that is institutional investors, non-institutional investors, and retail investors. See, under listing regulation, there is a separate provision which is called shareholding pattern. Every listed entity has to submit shareholding pattern on a quarterly basis within 21 days from the quarter end. When we check shareholding pattern, in shareholding pattern, there are two parts. First part is promoter shareholder. Second part is public shareholder. Promoter shareholder includes domestic promoter shareholder and foreign promoter shareholder. So who is promoter? Promoter means person who is promoting a company. And it includes person whose name is entered in the annual report of a document, or person who is controlling the company. These person will come under the category of promoter group. Okay, promoters. Second part will be public shareholder. Public shareholder we can bifurcate into three parts. First is institutional investors. Second is non-institutional investors. And third is retail investors. Who is institutional investor? Institutional investor means investor which is an organization which is registered under particular statute, like mutual fund, banks, financial institution. So qualified institutional buyers, all of them are coming under institutional investor category. On the other hand, we have retail investor. Retail investor means investor whose investment value is up to 2 lakh. Retail investor means investor whose investment value is up to 2 lakh. So who is non-institutional investor? Non-institutional investor means investor other than institutional investors and retail investor. So these are the three eligible investor under ICDR regulation who is eligible for investing their fund in social enterprises. Okay. So next is eligible condition. See, we have to satisfy 3 to 4 eligible condition to become organization as social enterprise. First condition must be NPO and for-profit organization must be functioning with the objective of a social intent. Their main objective must be social intent. How can we determine whether that organization is functioning with social intent? You have to check second eligibility criteria. That is, social enterprises must be indulged in any of the 16 activities. There are 16 activities which is mentioned under ICDR regulation, like eradication of hunger, poverty, malnutrition, education, healthcare. So likewise, 16 activity has been prescribed under ICDR regulation. So such social enterprises must be indulged in any of these 16 activities. So that is the second checkpoint. So first checkpoint must be social enterprises must be undertaken with undertaking activity with social intent. Second eligibility criteria will be they must be indulged in any of the activity of 16 activities. Third checkpoint is social enterprises must target underprivileged or less privileged population area. So social enterprises must spend their fund in less privileged or underprivileged population region. And fourth checkpoint must be social enterprises spending their fund in activity. That activity must be 67% of total activity, which is considered as eligible activity. See, we have 16 activities which is treated as eligible activities, right? So out of total activity, 67% of activity must be from eligible activity. Out of total activity, 67% of activity must be from eligible activity. Okay, that is one thing. Second thing, revenue generating from the activity must be 67% from eligible activity. See, we have total activity and revenue generating from such activity must be 67% from eligible activity. And also expenditure spending must be 67% towards eligible activity. And last, this activity must be spent towards 67% of a underprivileged population. So these are the eligible condition to be treated as a social enterprise. So I will repeat once again. There are 4 checkpoints. First checkpoint is social enterprises must be indulge in activity with social intent. That is first checkpoint. Second checkpoint is they are indulging in activity among 16 activities prescribed under ICDR regulation. Third checkpoint is they are spending their fund in underserved or less privileged population. And fourth checkpoint is social enterprises are involving in 67% of activity from eligible activity. See, if we have total 6 activities, out of which 67 activities must be from eligible activity. Likewise, revenue, expenditure, and beneficiary must be from eligible activities. Okay. And last point will be not eligible to be treated as social enterprises. There are certain cases in which organization will not be treated as eligible activity, like corporate foundation, political and regional, political and religious organization, or a professional or trade association, housing companies like that. So these are the organization which will not be treated as social enterprises. So each social stock exchange will have a governing council, which is called Social Stock Exchange Governing Council. So Social Stock Exchange Governing Council is mainly to check whether a stock exchange is functioning in a particular, that is in a standardized manner. That is one thing. Second thing is issue rules and regulation for controlling and promoting social stock exchange, and such other duties as prescribed by SEBI. So like this is the duties and responsibilities of a social stock exchange governing council. Next, registration for NPO. As I told you, registration for NPO is mandatory, even though raising of capital is optional for them. So registration is mandatory. Listing and raising of capital is optional for NPO, whether can raise capital from stock exchange or they need not go for raising of capital from stock exchange. It is optional. SEBI will prescribe a minimum requirement. SSC will also prescribe minimum requirement. So based on that, they have to get itself as registered with social stock exchange. So various fundraising avenue for social enterprises. As I told you, there are two types of social enterprises. One is not-for-profit organization and second one is for-profit organization. So not-for-profit organization, NPO, they can raise fund by issue of a zero coupon, zero principal instrument and also donation through mutual fund scheme. I have deliberated on this topic earlier. And second topic is for-profit organization. So for-profit organization can raise fund by issue of equity shares on main board, MSME, innovative growth platform likewise. And also they can issue debt instruments also. So we have discussed eligibility criteria, then that is a different mode of raising capital, etc. So there are ineligibility criteria which is mentioned under ICDR regulation. Ineligibility means if any of the social enterprises which is coming under any of this case, they are ineligible to be registered as social enterprises. Okay. Number one, if social enterprises, its promoter, director, or any of the trustee is debarred by SEBI. Debarring is nothing but SEBI will impose certain entity not to come to the stock exchange for raising the capital. They are debarred from raising capital from the stock exchange. So if social enterprises or any of the promoter or trustee is debarred by SEBI, then they are not eligible for raising capital from social stock exchange. Likewise, if social enterprises or any of the promoter or trustee are treated as willful defaulter by RBI, in that case also social enterprises are ineligible to raise fund from social stock exchange. And also promoter and trustees are declared as fugitive economic offender by central government. Fugitive economic offender is nothing but a person who is declared as economic offender and who gone out of India. They are treated as fugitive economic offender. Likewise, we have various examples like Vijay Mallya, Nirav Modi. They all are declared as fugitive economic offender. Next topic is zero coupon, zero principal instrument. See, there are certain terms and conditions for issuing zero coupon, zero principal instrument. So as I said, zero coupon, zero principal instrument can be issued only by NPO. That is the first and foremost condition. NPO can only issue zero coupon, zero principal instrument. Condition number one. Condition number two, if NPO want to issue such instrument, then NPO has to register itself with the social stock exchange. NPO has to register itself with social stock exchange. That is condition number two. Condition number three, zero coupon, zero principal instrument must have a clear maturity period. Clear maturity period means it will be issued for a period of 1 year, 2 year, 5 year, like that. Okay. So that is third condition. That is this instrument will be issued with particular maturity period. Fourth condition is fund which is raised through issue of such instrument will be invested in certain activity which is having prescribed time period. Fund raised through issue of this instrument will be invested in specific project or activity which is having prescribed time limit. And that project must be eligible social activity. So these are the conditions which need to be complied before issuing zero coupon, zero principal instrument. So I'll repeat once again, zero coupon, zero principal instrument can be issued only by NPO. Second is NPO must be registered itself with social stock exchange. 3, this instrument must have a minimum maturity period. 4 is fund raised from such instrument must be utilized for the project which is having prescribed time period. And 5th condition is project must be eligible project, that is eligible project which is prescribed under 16 activities under ICDR regulation. So these are the conditions which we need to be complied with before issuing zero coupon, zero principal instrument. Okay, and last topic under ICDR regulation is termination of listing of a zero coupon, zero principal bond from social stock exchange. Termination is nothing but it can be named as delisting or buyback. So there are 2 instances in which termination of listing will happen. First thing is object for which fund has been raised has been achieved. We have achieved the object for which fund has been raised. And second situation for termination of listing is tenure to achieve the objective has also completed. Tenure to achieve the objective has also been achieved. So these are the 2 instances in which termination of listing will happen. Termination is nothing but it is just like a delisting or buyback. So we are moving on to some practical perspective in fundraising. As we discussed, we have 2 method in which fund can be raised, that is public issue and private placement. So we will discuss one by one what is public issue and what is private placement. First, we will move on with private placement. Private placement is nothing but issue of a particular instrument to the selected group of non-person. Issue of instrument to the selected group of non-person at a prescribed price at a prescribed time period. So private placement is nothing but issue of an instrument to the selected group of non-person at a prescribed price. So under this mode of raising capital, instrument will be issued only to the known group of person. We know certain investor, and this instrument will be issued only to non-person. This is called private placement. On the other hand, we have public issue. Public issue means issue of shares to the public for raising capital by issue of instrument. So we are issuing instruments to the general public for raising the capital. That process is called a public issue. Through public issue, general public investor will become shareholder or debt holder of that company. So first we will check what is the practical perspective in the case of private placement of a zero coupon, zero principal instrument. As I told you, zero coupon, zero principal instrument can be issued only by non-profit organization. So if first and foremost thing they have to do is they must get registration from social stock exchange. Then only they can raise capital from the exchange. So first step would be we must require in principle approval from the stock exchange for issuing zero coupon, zero principal instrument. So in principle approval is nothing but you have to get in advance approval from the stock exchange before proceeding with issue. Before fundraising, we have to get in advance approval from the stock exchange. And that process is called, and that approval is called in principle approval. Certain document we have to file with the social stock exchange for getting in principle approval. They are draft fundraising document, then we have to submit a confirmation stating that draft of a document contain all the information as prescribed under ICDR regulation. So that is a declaration by issuer company, that is social stock, the social enterprises. So that confirmation has to be given by social enterprises. Third document which we need to be submitted is confirmation by either issuer or a social auditor or social impact assessor stating that they are eligible to be an MPO and to issue zero coupon, zero principal instrument. So that declaration has to be signed either by issuer or social auditor or statutory auditor. Likewise, there are certain instruments which we need to be filed with social stock exchange for getting in principle approval. So in principle approval is nothing but in advance approval. Before proceeding to raise fund, we have to get in advance approval from the stock exchange. So after getting in principle approval, then we can very well go ahead with fundraising. Once fundraising is completed, then we have to do a next step, which is called listing of a zero coupon, zero principal instrument. So for listing of zero coupon, zero principal instrument, we have to submit following documents, which includes listing application. Listing application is nothing but we request a stock exchange stating that we are proposing to list so much of instrument with the exchange. Kindly give the permission. So this is called a listing application. So listing application duly signed by authorized signatory has to be submitted. That is first document. Second document is fundraising document as per SEBI ICDR regulation. Final fundraising document has to be submitted to a social stock exchange. Third document is credit confirmation received from depository. The credit confirmation is nothing but it is a corporate action stating that this zero coupon, zero principal instrument is credited in the demat account of the investor. That credit confirmation must be given by depository. Credit confirmation is nothing but zero coupon, zero principal instrument is credited in the investor's demat account. That confirmation has to be obtained from depository. That confirmation is called credit confirmation. Likewise, resolution by governing body, undertaking from NPO, etc. has to be submitted for getting listing approval. So these are the documents which we need to be submitted before the social stock exchange for getting instrument listed in the exchange. So private placement is over. We are moving on to public issue of a zero coupon, zero principal instrument. Here also we have three steps. First step is, again, we have to get the in principle approval for raising capital through public issue. So before public issue happen, this social enterprises has to apply before social stock exchange for in principle approval. So these are the documents which we need to be submitted to the exchanges. It is a more or less similar document, but one or two documents are different because it is public issue now. So additional document will come. So this application must be submitted along with some processing fee. Processing fee will come to around 25,000 like that. So once public issue is completed, then we have to submit these documents like minutes of the meeting, signed copy of basis of allotment, fundraising document, certified true copy of material contract and document. Likewise, these documents we have to submit to the social stock exchange. This is the second phase of public issue. And third phase of public issue is listing. As I said, it is similar to private placement. For public issue also, we have to submit the application, listing application. So for listing application, following document is required to be submitted, like listing application, listing agreement, confirmation from NPO, certified true copy of resolution passed by governing body. Like that, we have to submit this much of a document before stock exchange for getting approval for listing. So these are the various NPOs which is registered and listed with social stock exchange. As on date, there are 92 NPOs registered and or listed with the NSE social stock exchange. So this I have taken from NSE social stock exchange page. You can also refer exchange portal. This details is available in that. So for listing of that zero coupon, zero principal instrument, we all have a lot of opportunity. We all have a lot of work to be done. So if we are moving on to self-practice, then definitely NPOs will come to us for making this documentation. So a lot of scope is there in these areas. So we have completed with ICDR regulation. So let us move on to question and answer. We'll check whether your knowledge is impacted or not. Let us check. So question number 1, what are the criteria for registration on social stock exchange in respect of not-for-profit organization? See, as I told you, not-for-profit organization need to be mandatorily registered with social stock exchange. So there is a circular which is called SEBI circular dated September 19, 2022, which states about framework on social stock exchange. In that, it is mentioned about criteria. What are the criteria which a not-for-profit organization must be complied with? It includes not-for-profit organization must have 3 years track record. Not-for-profit organization must have 3 years track record. Second condition is they must be registered as charitable institution under Income Tax Act. Third criteria is they must be registered under section 80G under Income Tax Act. So likewise, that circular prescribes about criteria for a non-profit organization before getting registration from social stock exchange. That is question number 1. Question number 2, is it mandatory for non-profit organization to get registered with social stock exchange to seek listing? See, I've already explained all these questions. See, for a non-profit organization, registration is mandatory. For fundraising, for NPO, it is optional. So mandatory is this registration is mandatory for NPO. Third question, development impact fund, a structured finance project. I have explained that concept also. Development impact fund is nothing but it's a debt instrument issued by social enterprises, and that social fund will come to such enterprises only after that activity has been undertaken. Suppose an enterprise is giving free of cost education to below poverty line. So as far as development impact fund is concerned, you should undertake that activity. After that only this development impact fund will come to social enterprise. So this is called development impact fund. Question number 4. Will an NPO promoted by promoters of body corporate be eligible to apply? See, in ineligibility criteria, it is mentioned that corporate foundation can't be treated as social enterprises under ICDR regulation. So the entity promoted by body corporate or entity which has investment of more than 50%, they can't be classified as social enterprises under ICDR regulation. That is question number 4. Question number 5. What proof is needed to demonstrate that NPO has been in operation for 3 years? So we have various proof, like we can present activity report, we can present financials to demonstrate we have a track record of 3 years and we are involving in social activities. These are the proof. Question number 6. Can an NPO that is not registered on NGO Darpan portal can an NPO that is not registered on the NGO Darpan portal register on social stock exchange? See, NGO Darpan portal is nothing but it is mandatory for NGO to be registered under Darpan portal. Darpan portal is nothing but NGO can avail various schemes from that portal. They will get grants from the government to that portal. So for NGO, it is mandatory that they must be registered under Darpan portal with the central government. So only NGOs which that has been registered with Darpan portal can only registered on social stock exchange. Okay, so Darpan portal, it is mandatory for NGO to be registered. So NPO who want to register themselves with the social stock exchange, it is mandatory that they must be registered with NGO Darpan portal. Question number 7. Is this mean for Indian entities only, or international NPO can also get registered? The ICDR regulation says that NPOs must be Indian NPOs. International NPOs can be registered themselves as social enterprises with social stock exchange. So Indian NPOs are only entitled to be registered as social enterprises. Question number 8. Suppose we get registered as social enterprises, and while moving forward, if at any point of time, if we fail to follow any guidelines, what will be the potential repercussion? Suppose after registration, we are not complying with eligibility criteria, and if SEBI found out at the later stage, its potential repercussion after effect will be huge. SEBI can impose fine or penalty under SEBI Act, and also order for adjudication also. So these are the after effect if we are not complying with eligibility criteria after we have registered as social enterprise. Question number 9. Are for-profit organization eligible to issue zero coupon, zero principal instrument for raising capital? Answer is no. See, as I told you, zero coupon, zero principal instrument can only be issued by NPO, non-profit organization. For-profit organization can issue only equity share or either debt instruments they can issue. Question number 10. Can zero coupon, zero principal instrument can be issued in physical form? No. See, we are in the digital era, and also SEBI is supporting digitalization. As a part of that, ICDR regulation prescribed that all instruments, including equity shares, preference shares, bond debentures, etc., should be in a dematerialized form. So no social enterprises can issue instruments in a physical mode. That is the answer to question number 10. Is there any limit for issue of a zero coupon, zero principal instrument? See, there was a limit of 1 crore under ICDR regulation, but in the year 2023 December, SEBI had taken away that condition. Earlier, there was a condition stating that minimum issue size must be 1 crore. Now, that condition is no more. SEBI has taken away in the year December 2023. Next question. Are instruments listed by social enterprises available for trading in social market, secondary market? See, instruments issued by non-profit organization, that is zero coupon, zero principal instruments, are not available for trading. That will be listed, but it is not available for trading. But on the other hand, for-profit organization can list their shares or debt instrument for trading. So for-profit organization can list their instruments for trading. That is the answer to the question. Is there any lock-in or minimum period requirement between registration and raising of capital? See, as I told you, NPO is required to be mandatory registered with social stock exchange. After that only they can raise capital from the market. So here the question is there any minimum lock-in period or minimum period between registration and raising of capital? So under ICDR regulation, there is no such condition. After registration at any point of time, you can raise the capital. Next is merchant banker is required to be appointed for preparing draft fundraising document. To be frank, under ICDR regulation, for every public issue, every other issues, merchant banker is mandatory. That is, all issues except rights issue, bonus issue, for every type of issue, merchant banker is mandatory. But in the case of zero coupon, zero principal bond or public issue, in the case of social enterprises, merchant banker is not at all mandatory. Merchant banker is not at all mandatory. Next is there any validity period for observation issued by social stock exchange on draft fundraising document? See, there is a valid time period that is 6 months within which we have to raise the fund. That is, if observation is given by social stock exchange, then your time starts now till 6 months. Within 6 months, you have to raise the fund. Otherwise, that offer document will be lapsed. Next question. How will the foreign funding and local funding be managed in single instrument? Or is there any separate instrument for NRIs and foreign investors? See, social enterprises can raise fund only from Indian investors. That is, Indian institutional investors or non-institutional investor or retail investors. These enterprises can't raise from foreign investors or NRIs. That provision is not there in ICDR regulation. And last question will be whether zero coupon, zero principal instrument holding can be transferable. See, this instrument can be transferable to the relative as a part of transmission, but it can't be traded in the stock exchange. That is the answer. So there is no provision for trading of social zero coupon, zero principal instrument in the stock exchange. This instrument can be transferable to the immediate relative as a part of transmission. So that's all about ICDR regulation. So we are moving on to last part of our regulatory framework, that is SEBI LODR regulation. So there are 4 disclosure which we need to be kept in your mind. See, first one is applicable for profitable social enterprises, that is for profitable enterprises. See, for profitable enterprises, they need to have a same disclosure requirement as prescribed under Chapter 5 of LODR regulation. That is from Regulation 15 to Regulation 48. The same disclosure requirement this for-profit organization has to be complied with. So that is exhaustive, this thing. If time permit in future, we will discuss that part also. So for profit organization, they have to comply with Chapter 4 of LODR regulation, which includes say constitution of board of director, constitution of audit committee, constitution of risk management, related party transaction. So these are the provision which is mentioned in the regulation from Regulation 15 to Regulation 48. For NPO, non-profit organization, they have to submit a disclosure that is called annual disclosure within 60 days from the end of financial year. So annual disclosure will contain the activity which they have undertaken, fund they have raised from the social stock exchange. Likewise, they have to mention in the annual disclosure. So annual disclosure is the one of the major disclosure which NPO has to be submitted to the stock exchange. Apart from that, they have to have a policy which is called a policy on materiality. The policy on materiality is nothing but every organization may have some material event, right? Material event may come, say a change in management, change in director, change in SCFO. Likewise, there will be some key event which may happen in the company. So as per this policy on materiality, we have to intimate material event to the stock exchange. And that has to be intimated within 7 days from the event happen. 7 days from the event happen. So here we have discussed three things. One is for profit organization, they have to comply with same disclosure requirement under chapter 4 of LODR regulation, right from regulation 15 to regulation 48. For NPO, they have to submit annual disclosure within 60 days from the financial year end, which contains information about activities undertaken, fundraise, etc. Apart from that, NPO has to have a policy which is called policy on materiality, which contain a certain event which we need to be submitted to the stock exchange. So such material event like change in management, financial result, or some key events which is happening in the organization, that has to be intimated to the exchange within 7 days from the event happened. Also, we have other disclosure also, that is annual impact report to the social stock exchange. The annual impact report is nothing but, see, we as a social enterprises are spending our fund towards the social activities, right? So whether that fund, whether that activity reach to the particular category of person, that we have to check. That is called impact assessment. So annually, impact assessment has to be undertaken by social impact assessor. I'm just deviating this SEBI regulation. See, under Companies Act, as we discuss section 135 relating to corporate social responsibility. See, under corporate social responsibility, there is a separate rule which is called Companies CSR Policy Rule 2014. In that, it says that every eligible company has to undertake impact assessment every year. So impact assessment is applicable only when CSR obligation is more than 10 crores and investment to the particular project is more than 1 crore in a particular financial year. Eligibility is total CSR contribution is more than 10 crores, out of which spending towards particular project is more than 1 crore. In such case, impact assessment must be done by social auditor. Likewise, under LODR regulation, annual impact report has to be submitted to the social stock exchange. And this report has to be signed by social impact assessor. Social impact assessor. So likewise, other disclosure as also mentioned, which includes a utilization of fund on quarterly basis. We have to give a report to the stock exchange stating that utilization of fund, how much fund we have utilized, how much which is spending with the social enterprises. So we have to mention in a report on a quarterly basis, and that has to be submitted to the stock exchange. An unspent amount must be kept in a separate bank account. So these are the different disclosures which NPO has to be complied with under LODR regulation. So we are done away with the regulatory framework, and the last PPT is opportunity for professionals. So these are the various opportunity we as a professional is having. One is social audit. As I said, social audit is nothing but we are assessing whether this particular activity has impacted society. So that audit has to be done by social impact assessor. So we have scope on that. Only thing, you have to get registered with self-regulatory organization. You have to get certification course qualified from NISM and hold valid certificate. So if you comply with this condition, you can do social audit. Likewise, you can do advisory on fundraising and compliances. You can evaluate social project in the sense ICDR regulation mentioned about 16 project. So you can advise your client that this fund can be utilized towards this much of activity to qualify your firm as social enterprise. So you can act as evaluator of a social project. Then advisory is there. Then you can conceptualizing social impact project. So if client comes to you stating that I want to spend so much of amount towards so much of activity, so they will tell you idea. So we as a professional, we can just frame a project and we can submit that to social enterprises. So they will implement that. So conceptualization of a social impact project is another area for we as a professional. And last one is registration and listing of NPO for profit organization project on SSC. So we discuss about registration and listing of instruments with the social stock exchange. So these are the opportunity which we are having. This is the final slide. I'm done away with the topic on social stock exchange. So I am having a advice to you all from a kind brother. See, you have to be updated with the latest SEBI circular, SEBI regulation to keep up to date on this matter. Only that you can survive in the global competitive scenario. So with that, I'm concluding my session. If you have any question, you can ask. Over to you, Akshada. Thank you.
Thank you so much, C.S. Mithun, for your enlightening session. Your insights have truly added value to everyone attending today. We now open the floor to questions from our audience. Please feel free to drop your queries in the chat box, or you can raise your virtual hand. If there are any questions, you can unmute yourself or just raise your hands, or even you can drop it in the chat box.
So you can ask any question, maybe on a social stock exchange or any topic from CSR. I'll answer to your query if possible. If not, I'll refer and come back to you. The social governance is the key area right now as far as budding professionals are concerned. See, we have CSR governance, ESG, then we have impact study. Likewise, there are many scope which we are having. So only thing you need to go in depth into each topic to become expert on that topic. So that is my advice. So if you have any doubt, you can ask.
Good evening, sir.
Good evening.
So, how does the social stock exchange in India differ from traditional stock exchanges in terms of listing requirements and investor?
See, a social stock exchange is only a segment in main stock exchange. See, we have National Stock Exchange, Bombay Stock Exchange, MCX, like that. So, social stock exchange is only a segment under main stock exchange, and it's the criteria is different as far as main stock exchange is concerned. So we have a main board, MSME board, then institutional trading platform, innovative growth platform, then social stock exchange. Likewise, there are different platforms. So for each exchanges, criteria will be different, And as far as social stock exchange is concerned, this criteria is much more minimal as compared to listing under main stock exchange. I mean main board. We need to only comply with that 4 criteria. That is, social enterprises must be undertaken activities with social intent. Then that activity must be out of 16 activity. Then spending must be in underprivileged area. And fourth one is our activity must be 67% of eligible activity, and revenue must be from eligible activity. So these are the criteria which we need to be complied with to declare ourselves as social enterprise. So compliance-wise, it is minimal for social enterprise as compared to main board.
So, like you said, that the social stock exchange, one of the requirements is that it must be operated in an underprivileged areas and the communities. But how
Right.
would it benefit the social stock exchanges if they work under these communities? I mean, they would go for their profit motive, right?
See, there are 2 ways in which social enterprises can be registered as a SC under SC with a social stock exchange. One is not-for-profit organization and for-profit organization. For-profit organization is their motive will be profit, but they are involving in social activity. But not-for-profit organization is they are purely working with a social intent. But answer to your query is we have to submit the report stating that we are spending our fund in underprivileged area. We have to determine which all are the underprivileged area. Likewise, we can spend. See, I'm working in Manappuram Finance Limited. We have a separate wing called Manappuram Foundation. So they identify various projects like education, healthcare, all those things. They make the annual action plan and spend accordingly. So it is up to us which all area we have to be identified. And that area must be underprivileged. And we have to answer to exchanges if they ask whether that area is underprivileged or not. So that report is called annual report, which we have to be submitted to the stock exchange within 60 days. Okay.
Yes, sir. Thank you.
Okay.
Sir, there is a question up in the chat box. Like it is from Sakshi. She wants to make her career in capital market, so she wants to know how to start and what your recommendations would be.
Hi, Sakshi. See, it's a good choice because a capital market is a competitive world. See, if you want to build your career in capital market, definitely you can do some certification courses with NISM, National Institute of Capital Market, Securities Market. There is a academy, so you can do the certification course, and you can do 3-year degree course also. So just go through NISM website. There are various certification course which is available. So with this certification, you can act as either a depository participant, stock broker, or even a merchant banker, or even portfolio manager. Likewise, you can act as. Okay, just go through NISM website. You will get all the certification course. Okay, which all are that certification course? Can you please just tell me 1 or 2?
So, I wanted to ask a question. It is apart from this. So, I wanted to go for dispute resolution in corporate field. Will it clarify as a 3-year mandate that has been declared by the Supreme Court?
Resolution professional under IBC, right?
No, sir. The 3-year mandate that has been ruled by the Supreme Court on 20th May 2025.
On what topic? Can you please
So on Supreme Court on 20th May, they declared that there must be a 3-year experience to a law student to clarify or to be eligible for the judicial exams. So I
Correct.
wanted to ask, if I work or dispute resolution for a company in corporate field, will it clarify that 3-year mandate period?
that I need to check, but I saw that I heard about that a Supreme Court verdict, minimum 3 years experience must be there to act as a lawyer. I mean that you are asking about that magistrate, right? To act as magistrate, right?
Yes, sir.
Yeah,
As a junior division lawyer or junior division judge.
yeah, correct. So I had a interaction with my colleague who is also a magistrate in a district court. He also tell that earlier there was no condition. So even a lawyer from say government law college or private law college, they can become magistrate. There is no criteria for that. So in order to bring expertism, Supreme Court has mentioned through its judgment, minimum 3 years must be there. So regarding that, your query, I need to recheck on that. I'll come back to you. So you can collect my phone number from a legal spec. I'll check and come back to you.
Yes, sir. Thank you.
Sir, if you can share your email ID in the chat box, students could drop their queries also.
Definitely. This is my mail ID. You can drop any query relating to any topic. I'll just check and I'll come back to you at the earliest.
There is one more question in the chat box, like it is from Shreya. She's asking if there is any tax exception for the same.
Tax
Exception. Eh,
exceptions.
Like I didn't get the question. Shreya, if you could unmute or if you could type the question again in the chat box, it would bring clarity.
Sir, I think she means tax exemption.
Tax exemption for what? The question was not clear.
Yeah, she hasn't unmuted yet.
Sir, if she's not in the meeting right now, I will get back to you with that question.
Please,
She's left.
please. You can drop me a mail. I'll just check and come back to you.
Sure, sir.
So I hope that a session was insightful to all of you. So this is my minimum knowledge, which I referred various books, SEBI regulation and various articles which was published in various social media. So I hope it was insightful to all of you.
Excuse me,
Good
sir.
afternoon, sir.
Good afternoon. Yeah, good evening. Yeah, tell me.
Good evening, sir.
Yeah.
I actually have one question that how the SSE frames and framework defines and the variety of the social impact and even the social purpose in legal terms, like how it's been defined.
What framework? Can you please explain once again?
Sir, actually the social impact and the social purpose, how it's being defined in the legal terms or in a legal framework.
See, in legal framework, nothing has been defined from my knowledge. See, it is up to the social impact assessor to evaluate, and they have to judge, and they have to put a mark on that. The last day we had a CSR committee meeting at our office, and at that meeting, one impact assessment report was submitted by one social auditor. So she physically came to various offices like school, healthcare center, and she visited each and every individual and get their feedback from that. So based on that review, she came to a certain conclusion and she put mark for each and every project. So we got out of 5, we got around 4.3 as the mark. So there is no criteria. What I'm trying to say is there is no criteria for impact assessment. It is up to us to prepare some structure for that. There is no format like what we have for a statutory auditor report, secretarial audit report. There is no format for social impact report. It is up to us. We can frame accordingly how advocacy skill, how we can draft this report nicely. It is up to us.
Okay, thank you, sir.
Okay.
Good afternoon, sir. Sir, I have one query.
Yeah. Good evening. Yeah.
So, yes, sir. So, why the entities as a profit organizers want to get registered under SCE, and there are already provisions also given under Companies Act and other acts as well, as you said. Then why they want to get registered under SSE, and also after becoming socially aware companies, what kind of benefits they can avail? Like what they look forward after becoming SSE? What is a requirement of basically becoming an SSE?
See, registration is mandatory for non-profit organization. For corporate with profit motive, it is not mandatory because they are already listed with social main board. It is not mandatory. It is for NPO. It is mandatory for getting registration. Why they have mentioned this criteria is because one, for NPO, they can do mandatory registration and it is optional for them to raise the capital from the exchange. Okay, that is the reason why registration is mandatory for NPO. For other corporate, it is optional.
Like, sir, after becoming a socially aware company, what benefits they can avail? What are the future benefits that they look forward?
Definitely,
Do they get personal benefits also, like regarding their company, or after becoming socially aware, showing that they are being socially involved in the society? Like what do they get? This is I want to ask.
Yes. I'll answer to your question in one word, that is they will get goodwill. Because once a social enterprise, that means not for profit organization, is registered with social stock exchange, their name and details will be visible in the exchange. So if an investor who is visiting or browsing the exchange platform, they will get to know about the enterprises, and if they are interested and they keen to know more about the enterprises, they will contact social enterprises, and if they are interested, they will invest in the organization. So mainly for the purpose of goodwill.
Okay, sir. Thank you.
Are there any more queries? I hope no. So to the attendees, just one reminder, there is a form, Google form, the feedback form that has been sent into the chat box. Kindly fill in for to be eligible for your e-certificates. And we'll conclude the session. Okay. So as we conclude this session, I would like to extend my heartfelt thanks once again to CS Mithun. Thank you once again, Mithun sir, for this enriching session. You have not only broken down the technicalities of the social stock exchange, but you have also helped us understanding it in a bigger picture where law, governance, and social good intersect. The session has helped the attendees to understand the relevance and future prospects of the SSE, along with a practical aspect for the private placement and the public issue in the SSE. The session was quite comprehensive and also clearly presented. And to everyone here, whether you are a law student, a company secretary in making, or someone working in the corporate advisory, we hope today's session has opened up a new way of thinking about your role in this evolving ecosystem. A big thank you for your participation, active participation, and the great questions raised. And again, a reminder: the feedback session is shared in the chat box. Kindly fill in the details to be eligible for your e-certificate. Please stay tuned for more of such webinars, learning sessions from our end. And until then, stay curious, stay informed, and keep working towards a more responsible and inclusive corporate of India. Have a great day. Thank you.
Thank you.
Thank you, sir.
Thank you so much, sir. Participants, please fill out the forms before you leave. Thank you, everybody. Have a great rest of the evening. Thank you, Akshara. That was really nice.
Thank you, ma'am.